Boards of Inquiry, an Ontario Law Society referee hearing claims against lawyers by clients, and a member of the Women's Issues Working Group of the Ontario Fair Tax Commission. During the 1980s, she was counsel and a negotiator for the National Association of Japanese Canadians in their successful claim for compensation from the Canadian government for their internment, property confiscation, and denial of civil rights. Justice Omatsu was called to the bar in 1977. A sole practitioner, she has specialized in the area of human rights, criminal, immigration, and environmental law. And we thank you very much for bringing a perspective from the bench today.
Thank you very much. Can you hear me? I'm basically speaking as a judge who sits in the trenches. And I appreciate the comments that have been directed to myself as a judge, and I think they are true. Judges do need help, and we do appreciate the help that you give us. And the first part of what I want to say in that regard is one of the findings of the Commission on Systemic Racism in the criminal justice system showed that 10% of judges appointed pre-1989 and also all the 10% of the Superior Court judges, only 10% of these judges believe that there is a race problem in the justice system. So I think you have to keep that in mind when you're thinking about the strategies that you're talking about today. So I suggest that you put yourself in my place and sit as a judge and think about how you would present your case, because I think that's a very effective litigation strategy in any event, to paint the picture for the judge by putting yourself in their place. So what do I see when I sit as a criminal trial court judge sitting every day in downtown Toronto? First of all, according to the 96 census, some 11.2% of Canada's population self-identify as visible minorities. The largest group of visible minorities are the Chinese, and they comprise 3% of Canada's population, followed by blacks at 2%. Majority of Canada's visible minorities live in Ontario, that's 53%, and an overwhelming number of these, 80% of them, live in Toronto. As well, there are some over 1 million individuals who self-identified as Aboriginal, and that was over 3 million who self-identified as visible minority. The attitudinal studies show that 1 in every 6 persons are defined by researchers as hardcore racists. And I think that's something that should be kept in mind, in particular when you're doing those challenge for cause jury cases. And this survey of 1 in 6 apparently has remained the same for the last 2 decades. There are also studies that show that all things being held equal, that visible minorities and especially African Canadians had consistently lower than average incomes and higher levels of employment. The Commission on Systemic Racism in the criminal justice system found that 58% of Metro Toronto's black residents, 31% of Chinese residents, and 36% of white residents believe that judges do not treat black people the same as white people. And more than 80% of those who perceive differential treatment believe that judges treat black people worse than white people. One note that I thought was promising in the Commission's finding was that there was a difference in the perception of judges in terms of the fact that 1/3 of of criminal judges who've been appointed after 1989 believe that there is a problem of race in the criminal justice system, as opposed to only 10% of those who were appointed pre-1989. Some reference has been made to Professor Walker's book and the cases that he had that indicate up to 1955, and I'm sure beyond that, that the Supreme Court of Canada have routinely upheld discriminatory laws and practices. And his book was very interesting, and I certainly highly recommend it, as well as that of Connie Backhouse, of course. Four cases that Walker talked about one was a 1914 case, Quang Wing, a Chinese-Canadian restaurant owner who challenged a Saskatchewan statute that prevented Chinese from hiring white women. And then the case of Fred Christie in 1936, and he was a black chauffeur who sued a Montreal tavern for refusing to serve him. And then in 48, there was the Wolfe case, and that was the case of Bernard Wolfe, who tried to buy a cottage that had a restrictive covenant. And the last case in his book was the 53 case of Harry Singh, who appealed a deportation order that stated he was excluded from Canada because he was a member of the, quote, Asian race. And distressingly, in each of these cases, and they were well argued, the Supreme Court upheld the discriminatory laws and practices. On a positive note, I think there has been a sea change of sorts in the recognition that by the Supreme Court of Canada that racism exists. And in the case of RDS, which I will spend more time on, Justices McLaughlin and Lerudebe wrote that the reasonable person must be taken to be aware of the history of discrimination faced by disadvantaged groups in Canadian society, protected by the Charter's equality provisions. These are matters of which judicial notice may be taken. And certainly that is a large step for the Supreme Court of Canada, given their previous history in the past century. And in fact, the Williams case, which panelists have referred to as well, was an important case because there was a unanimous Supreme Court of Canada position on that, on racial prejudice. And they did say that racial prejudice against the accused may be detrimental in a variety of ways. The link between prejudice and verdict is clearest where there is an interracial element to the crime, or a perceived link between those of the accused race and the particular crime. Racist stereotypes may affect how jurors assess the credibility of the accused. Bias can shape the information received during the course of the trial to conform to the bias. And I think that these cases show that we judges who sit in the trenches have been given sort of the green light by the Supreme Court of Canada to accept your arguments that you're going to make to us when you play the, as others have referred to it, the race card. I'm going to spend some time talking about the case that I'm sure you're all familiar with, R versus RDS. And that was the case, RDS was a young black teenager who was charged with various criminal offenses against a white police officer. And Justice Connie Sparks, who was the first black woman judge in the history of Canada, acquitted the boy and made some remarks which were challenged as raising a reasonable apprehension of bias on her part. Eventually, it made its way up to the Supreme Court of Canada, and the majority of the Supreme Court of Canada upheld Justice Sparks' decision. I'm also going to refer to the challenge for jury cases. We've had some reference to the Parks case. Parks was a black drug dealer who was charged with second-degree murder of a white drug user. There was the Williams case, which has been referred to. Williams was an Aboriginal who was charged with robbing a Victoria, BC pizza parlor, and Coe was a case where 3 Chinese were charged with trafficking in heroin. Talking about the jury cases first, at the first level, the defense counsel were denied the right to challenge jurors for cause, and eventually either when they got to the Court of Appeal of Ontario or to the Supreme Court of Canada in Williams, new trials were ordered because the court found that there was sufficient evidence of potential for juror bias and prejudice. Sitting as a judge, I have to say that in terms of our judicial education, because of all the studies and that exist that indicate that people have lack of confidence, I suppose, in the judicial system. To be fair, we receive judicial education, and we are being trained to be, quote, what I call race blind. And I distinguish this from being colorblind because that has a whole history in American jurisprudence. But in our training, we are, it's stressed, the Martin Luther King Jr.'s injunction that a person should be judged by the content of his character rather than by the color of his skin. And I take that to be certainly a good goal and a good step forward to ignore race in the evaluation of a witness's credibility. Obviously, there are some exceptions to this race-blind policy, and some reference has been made to that. That's Section 718.2 of the Criminal Code, which says that race in a racist acts in a race-based crime can be seen as an aggravating circumstance meriting more severe punishment, and also that alternatives to jail are to be considered, especially for Aboriginal persons. And then, of course, the Section 638 of the Code that allows the challengers for cause if a juror is not indifferent between the Queen and the accused. Now, getting back to the issue of contextualized judging, and that's basically was addressed in the RDS case, which I referred to, the case involving Justice Sparks. This is what Justice Sparks said. Well, perhaps actually, given the time, I'm not going to actually go into what she said. I do have a paper in the package of materials, and I hope that you will have a chance to look at it. It's not a finalized paper. I see it as a paper in process. But Justice Sparks' comments were considered very carefully by the Supreme Court of Canada, and basically 6 of the 9 judges said that a judge can take notice of social context. And they agreed you can take notice of social context if there is expert evidence, or there are studies or commission reports or findings. However, only a minority of the judges of the Supreme Court of Canada, and that's 4 of the 9, said that a judge could take notice of something from her personal experience only. And the 3 dissenting justices, Major, Lemaire, and Sapinka, felt that Justice Sparks taking consideration of her own personal experience they said its life experience is not a substitute for evidence, and they held there was no evidence before her to support the conclusions she reached. Now, I of course agree with Justices McLaughlin and Arruda Bay when they felt that Justice Sparks could rely on her personal experience. However, I do have some concerns in this area because although it's generally professors who are criticized for living in ivory towers, and of course Mr. Rosenthal is excluded from this, judges are certainly no less cloistered. And I think that trial judges sitting alone applying their personal views on social issues might well be advised to ensure that they do not suffer from a kind of myopia of vision that another panel member has spoken of that results from their particular privileged life circumstances. I would hope if there is a clearly debatable social issue before the court that counsel will present some kind of evidence from experts, scholarly articles, reports of studies, surveys, etc. And certainly the jury cases give you a whole range of papers and studies that can be referred to. I think that a way that we can, I'm speaking by we, I'm thinking about the judicial education and what have you, the way that judges, the situation can be addressed for judges is certainly are three ways. One, I think that we should improve the judicial education that judges receive to alert them that they may suffer from unintentional prejudices or that their life experiences are such that they may be unknowledgeable about particular life conditions of certain groups of people appearing before them. And I'm not sure if legal aid would cover this, but I would hope that that in appropriate cases that counsel could be asked to provide evidence in support. And then thirdly, I think that it would be appropriate that appellate courts be asked to determine whether a trial judge's life experiences in the situation of Judge Sparks or in the case of the Coe case, for example, or any of the jury cases at the lower levels, if the trial judge's experiences were borne out by other indices of social context in a situation where a trial judge relied only on his or her life experiences. In conclusion, I think that in terms of critical race theorists, and I do appreciate very much Carol's book, which I think is an important addition to the literature, that their insistence that racism is pervasive in these sort of politically incorrect times, I think that one tends to want to ignore that fact. And secondly, that I appreciate critical race theorists for their demand that in race-based cases that the social context be broadened to include the perspectives of the racial minorities involved. Given the recent decisions of the Supreme Court of Canada and the Ontario Court of Appeal, I think that Canada is a fertile ground for the application of critical race theory. And I'm referring to the Supreme Court of Canada's acknowledgement that racial prejudice exists and that it can result in miscarriages of justice against persons of color, and to their cautious endorsement of contextual decision-making. I think that this will continue to alter the dated reasonable man standard that is applied and will broaden judicial knowledge beyond the limited personal experience of a judge. I think that, as Justices McLaughlin and Arruda Bay observed, contextualized judging is essential to achieve genuine judicial impartiality in a society where racial biases persist, and that critical race theory and its application in critical race litigation, which Carol has described in her book, have the potential to change how criminal cases are argued, prosecuted, defended, and decided in this country. Thank you.
Thank you very much. It's very helpful and encouraging to hear those sorts of remarks from the bench, actually, given some of the other examples we've heard today about sort of the receptiveness, perhaps, of the judiciary to hearing some of these claims and grounded in critical race theory. So we appreciate that. I know we're a little bit over time. We do have another speaker, and I would encourage you to stay for that, because I think it'll be a very important wrap-up. For anyone who has to go, we do understand that, and thank you for your participation. Also, if people are willing, we'd probably like to hang on for a little while after so that we can take some questions. It's been sort of one-sided today, and probably people in the audience have a fair bit to contribute as well. So we encourage you to stay for that.
It's now my pleasure to introduce Charles Smith, who is the equity advisor. And I'm going to take a few minutes to tell you a little bit about Charles, because he is our first equity advisor. And in thinking of his title, I started thinking of other things such as builder of bridges, doer of good things, the man who makes things happen. And the reason for this is that in the time that Charles has assumed the position of equity advisor, he has adopted a very inclusive approach, set out to work with both the legal community as well as the community at large, building bridges in terms of bringing us together on crucial issues. You may have noticed that you've received a number of invitations to special events at the Law Society involving a number of communities: the Aboriginal community, the Filipino community, the East Asian community. You've been invited to seminars involving leading women scholars on issues with respect to the law, and much of that has come about because of Charles Smith. You will also note from his CV that he was previously employed with the Access and Equity Center for the City of Toronto. There he instituted a number of programs and policies dealing with employment benefits for same-sex partners, revised workplace harassment policies and procedures, multicultural funding, ethnocultural racial access to police services. In addition, he has written numerous articles and publications, all of which are available in his CV in your binder. A framework for action goals, principles and implementation guidelines for ethno-racial and Aboriginal access to metropolitan grants, access and equity staff development. More recently, at the Law Society, he has been instrumental in preparing reports with respect to the response to the Canadian Bar Association report on racial equality in the legal profession, equity and diversity in the bar admission course reform, discrimination and harassment council program, which has now been instituted and is a reality through the Law Society of Upper Canada. I think one thing that I also want to note briefly is his publication of poetry. I think it's always nice to know that beyond what we do, we have special interests and special talents. So it's my pleasure to present to you Charles Smith.
Thank you, Grace, and I want to thank all the panelists who have preceded me. It's a very daunting challenge to try to bring some sense of closure to what has been a rather rich and fulfilling morning. I think as we sort of went into planning for today, I don't think any of us were able to imagine the wealth of information, knowledge, expertise, and precedence, I suppose, for those who are lawyers, that would come forward in this morning's round of discussions. It certainly gives us a lot of thought about how to build on this kind of activity and where we can move into the future in terms of educating members of the profession. And what I think is very important, I think Grace is right, bringing people together who, through their day-to-day work, don't have much time to really speak to each other and reflect upon what they're doing individually and how that might benefit their colleagues who are working in different areas and so on and so forth. So I really want to thank everybody for this morning, and I've really enjoyed sitting back and listening. I'm here for 3 reasons, and I'm going to try to be as brief as I can because I know how it feels to sit and listen for a long period of time and not be able to ask questions or raise points. I think it's important to talk a little bit about that the Law Society, number one, takes racism in the legal profession very seriously. So I want to talk about that a bit. I want to talk a little bit about why we take it seriously, and then what we're doing to begin to address issues of racism as well as other forms of discrimination in the legal profession. You have a text of I guess, an article that I've written, which is in your binder. I think it's at tab 5 or 6, and it's called Addressing Racism and Equity in Canada Today. The sort of subtitle is Now More Than Ever. In reconsidering, I really want to call it the challenge of our time, because I think it speaks more importantly to the issues that we really need to think about. In terms of the Law Society's interest in issues of equity and diversity, one of the things that you probably are familiar with is that in 1997, the Law Society adopted what's called the Bicentennial Report on Equity Issues in the Legal Profession. It adopted it at its bicentennial, and I think it's not an insignificant opportunity that the Law Society took advantage of. It's 200 years after the Law Society came into being. It's the oldest organization of its kind in North America. As most of you probably know, it's modeled on the Inns of Courts in England. And essentially, as the oldest, it tends to like to pride itself on being a trailblazer and a pioneer on new developments in regulatory areas for members of the legal profession. Also significantly, it's 100 years after Clara Brett Martin was called to the bar as a first woman. These things in my conversations with the authors of the report were not lost on convocation at that time, were certainly not lost on the working group that put the report together, and I would suspect is probably not lost on members of the profession who are eager and interested about the ways in which the Law Society is bringing forward these issues. It was seen as both an opportunity to celebrate and also an opportunity to challenge and to prepare for the future of the profession, essentially, as I've heard the current treasurer, Bob Armstrong, say, who was also a part of the working group that brought forward that report. Interesting enough as well is it was 10 years after the Law Society first established a committee looking at women's issues. This committee was established in 1987-88, and it was the first time that the Law Society, as a body, began to recognize that there was, that the profession was male-dominated, and that issues regarding gender, particularly as it affected women, had to be addressed in some form at convocation. So a standing committee was created, and I think it was called the Women's Committee in Law. Shortly after that, as more and more women began to enter the profession, so did people of color, so did Aboriginal people, so did people who would begin to declare that they were gay and lesbian and so on. And those individuals began to speak to the Law Society in various ways. For example, the Black Law Students Association of Canada was instrumental in doing a survey of members of the profession where it was discovered that many lawyers thought that the Human Rights Code did not apply to them. In fact, went so far as to assert that they did not have, that they could do things that actually were contrary to the code. This came out in one of the publications the Law Society put out in about 1994 that helped to establish the Law Society's Rules 27 and 28. Those are rules dealing with sexual harassment and non-discrimination. As time moved forward, we began to hear concerns about Aboriginal students in the bar admissions program. We also began to hear about concerns of French-speaking lawyers, both in the bar admissions program and in the profession, their success in becoming lawyers and in practicing law, and in ways in which the administration of justice either recognized and supported the bilingual nature of our country or did not, and what did that mean to French-speaking practitioners and to their clients. The Bicentennial Report captured a lot of this information, a lot of this energy that was coming out from new members of the profession, and began to look at how to provide an overall response that could deal with issues affecting Aboriginal peoples, racial minorities, people with disabilities, gays and lesbians, women, et cetera, et cetera. And there were 16 recommendations that were adopted. They fall in 6 areas, and I'm just prefacing this to sort of give you a sense of why we feel this is so important at this point in time. They were in policy development, in providing resources to the profession, in education, in governance, in regulation, and internal operations. One recommendation I just want to touch upon very briefly because I think it speaks to the heart of all the others is Recommendation 1, which principally says that the Law Society will ensure that all of its policies and programs are A, non-discriminatory, and B, will promote equity and diversity. So it's a recognition of discrimination as a reality in the profession, number one, and a commitment to identifying discriminatory practices, policies, etc., and eliminating them, and going one step further, promoting the notions of equity, which I think we all accept in the room is defined as trying to ensure equal outcomes for people who are competent in all respects. So it kind of said it will take positive action to deal with issues of discrimination within the profession. The other 15 recommendations are in specific areas that deal with either education, as I mentioned, or with how people participate in our governance process, or how we as the Law Society can be a model to the profession. So I'd talk a little bit about why we're doing what we're doing. And I think you've heard already through the 3-hour session this morning, very numerous points that we have certainly heard in a variety of ways, whether it's been through seminars such as these, whether it's been an examination of cases that have gone before the court, whether it's been in our own discipline process, and how do we begin to look at issues where the personal characteristics of the person, either counsel or complainant, become important to the case that comes forward. Another issue, and with hearing and understanding the many things that are coming forward, it is really incumbent, and I think the Law Society has seen it as so, to acknowledge as well as to educate and to provide a forum for people to get together, such as today, or as Grace alluded to, the women's seminar series that we had about a week ago, to begin to talk to the members of the profession about what these quote unquote, I don't want to say, I don't like the word new, because when I look in research around some of these stuff, they're not so new, but to what these emerging issues and doctrines are. And I mean emerging in a sense of how they're beginning to have an impact in the efforts to change the way our society operates and our institutions, which include the administration of justice. Another particularly important point, which has been talked about a bit, and you can look in tab 6 for some of this information, is around demographic changes, particularly in Ontario. If the population of Ontario in 1990, as I think it was about 9 million people, we have to assume that with immigration levels in the 1990s being at 225 people per year, and statistically it can be demonstrated, half of those people settled in the province of Ontario. So every year over the past decade, we have seen more than 100,000 people settle in this province, to the point where in the past decade, we can say that 1 million people have immigrated into Ontario from other parts of the world. Where have these individuals come from? They have come predominantly from Asia, Africa, Latin America, and the Caribbean. And what it essentially has meant is that issues of race, issues of language, issues of culture, issues of religion have had more of an impact, not because the rights are different than they were before. I think Kimberly's point and others who have talked about racism being embedded in the first impact between the European colonists and Aboriginal peoples is clearly true, but it becomes more pronounced when the population changes to such a point where in Metro Toronto, for example, we suspect that right now over half the population are people of color. In 1963, for example, racial minorities were measured at 3% of the population in Toronto. Right now, and this is some of the demographic studies I did in my previous employment, we suspect it's 53%. That's a 50% change over a 40-year time period. The implications that has to our society are profound, particularly when we begin to look at how our value systems, how our behaviors, etc., are based upon norms that are from one part of the world, in this case Europe, where people who run into those come from other parts of the world, have different value systems, and it becomes particularly more important when we recognize that those Eurocentric value systems have principles of racism embedded at the core. And a number of people have talked about the legislation that has come into pass, etc. I don't want to repeat those here. What I'd just like to spend a bit of time on, and I'll try to bring this to a close, is just to reinforce some of the points that Carol Aylward talked about in terms of the role of culture in the social construction of race and racism. When we look at and research how racism became contrived, we come across a couple of theories. One is that it was ordained through divine right, or through God's sort of parceling out of species, I guess is a quick way of saying it. So people refer to biblical references about the children of Ham and so on and so forth. Those were, in case you don't remember, the ones who had some difficulties back sort of, I guess, the biblical mythologies, and so they were people who were dark-skinned, etc. They were the ones who were being spurned. Up to early science and anthropology, which began to develop racial categorizations that also reinforced these early biblical theories. So they would do things like measurements of body parts, whether brains, eyes, or heads, et cetera, to determine various species. Well, what's interesting, and Connie Backhouse points this out in her book, The Color Coded, those who were doing the measurements, those who were coming up with the categorizations were Europeans. They were white. Interestingly enough, each time the apex was drawn, these Europeans were at the top of the scale, and others were somewhere else, falling variously below from in one way or another. This becomes very important understanding where race plays a factor in our society, that these are not natural attributes. They are, I guess we would say, man-made attributes, and they were done in either some way for pure scientific curiosity or for a particular purpose, to justify certain behaviors, that it was okay to do certain things like have slavery or like civilize Indians, et cetera, because we were not dealing with the quality of individual that came out of European stock. We were dealing with lesser quality persons. There are a number of theoreticians that I quote in my paper that you have, so I won't go into them there. But when I say that these are not new doctrines, one of the things I looked at, and I haven't opened his books for some time, is there was a quote in my mind of William E. Burghardt Du Bois, which I remember reading something like, the history of the 20th century is the history of the color line. So the other day I went trying to find this quote and try to find a quote of Du Bois in his massive volume of work is, well, forget it. Anyway, I didn't find that quote, but what I found were some very interesting writings that he authored about World War I and the importance of color to that war. And it was interesting, his point was that it was essentially European powers looking at how to divide up what we now call the developing world. And if you look at the impact of the German nation, France, and England, et cetera, in Africa in particular, you could see that the powers of imperialism were having some difficulties in drawing borders that they could all respect. Well, Du Bois' thoughts were then reinforced almost a half a century later by Frantz Fanon in the first Pan-African Congress in 1956, where he talked about the same hegemony having an impact upon nations that were declaring themselves were being liberated or were in the process of liberation. And it follows through to a recent article by Charles Mills in his book, or in one of his articles called Racial Polity, which is 1998, where he basically says much the same, that we're still dealing with the aftermath of European colonialism and its impacts upon our society. And the issues of race that were embedded in the colonization of parts of the world are things that we're still seeing today. So what does that mean in terms of law? I think you've heard a lot already. But I think if you look deeper into James Walker's book or into Connie Backhouse's book or to another book by Clayton James Mosher, which looks at systemic discrimination, I think it's called Discrimination and Denial, Systemic Discrimination in Ontario's Criminal Justice System. And again, it's a historical review from 1892 to 1961. You'll find a lot of verifying information that supports the things that both Backhouse says and that Walker says and that Carol Aylward says and that many of the panelists this morning have said in one form or another. So what we have very clearly, and why the Law Society sees this as very important, is we have a society in which race becomes very determining factors to people's lives, denying opportunities and providing privileges based upon the color of one's skin, based upon one's cultural backgrounds and so on and so forth. And how it impacts upon law, and I think I'll, if you don't mind, Madam Justice, one of the articles that Madam Justice Omatsu has written is looking at judicial impartiality. And she quotes, I think, Professor McCormick, who talks about that there may be this view that the Supreme Court, in fact, supports the underdog, but if you look at it in balance, it tends to have privilege-reinforcing powers. And she further argues, sorry to embarrass you if I am, but I think it's a rather critical point, that many of the cases where people who do not come from the communities that these judges do, they're unfamiliar with them. So I think Donald's point earlier about the cultural conflicts or the cultural divides, you know, his story resonates with me and probably resonates with many other people in the room, but it certainly did not resonate with certain judges. And the points that people raise in critical race theory about storytelling, about trying to lay a context, about trying to educate members of the judiciary or Crown Counsel, etc., about different ways of life become very important. So in summation, I think it's really important that the Law Society has begun to look at these issues and to do them in a variety of ways. We've been very impressed with some of the scholarship coming out of the Aboriginal community, whether it's Patricia Muntura Angus or John Borrows, others who have brought forward issues about Aboriginal right and title and how it has impact not only on law, but on procedures. Some of the stuff that Patricia Muntura Angus talks about in terms of precedent. Well, if there aren't many Aboriginal cases that are beneficial to Aboriginal right and title, there aren't many precedents that one can cite. How do you begin to argue forward? And I was unclear until just reading one of her recent books that apparently until the 1950s, and Kimberly may be able to correct me if I'm wrong here, that Aboriginal people weren't able to seek counsel.
That was an offense.
Yeah. That's 1950. It's not that long ago. So if we wonder why there aren't many Aboriginal cases arguing right and title, well, they would not have had Aboriginal lawyers steeped in the culture and would not have been able to seek counsel to do that. The final points I guess I wish to talk about is what are we doing at the Law Society to begin to address these and other issues? Well, critically, it's important that we get our own house in order. And one of the things that we're doing is we've had all of our departments develop what are called equity and diversity action plans. And those ways in which all of our departments, from discipline council to education, et cetera, begin to examine their programs and policies and to ensure that it conforms to recommendation 1 of the Bicentennial Report, that it's non-discriminatory and that it promotes equity and diversity. And how it has an impact on the variety of communities that I've mentioned earlier, people of color, Aboriginal people, women, gays, lesbians, people with disabilities, et cetera. In the bar admissions course, there's a reform process going on which is embedding those issues in terms of how we provide education to those people who will be called to the bar. Everything from the way in which the material looks, the kinds of cases that are brought forward, whether in property or in litigation and so on and so forth, need to look at what are the voices and words, et cetera, the images that come forward. Who are the instructors? Who are the section heads? Etc. Do they reflect a diverse population? Can they bring in issues of equity into the subject areas that they're teaching? In the rules of professional conduct, which are going to convocation fairly soon, one of the things we were able to bring forward to that task force was the notions that even though Rule 27 and 28 may have been rather advanced for our time here in the Law Society, they still fell short of definitions of constructive discrimination and positive action are both within the Charter and the Human Rights Codes. And that certainly members of the legal profession would be first to ensure that we abided by law, particularly in this particular area. So there have been some revisions to the rules of professional conduct to embed those things, which will be very interesting in terms of discipline cases, I suspect, in the next while. In public education activities, Grace has mentioned a few things already, but what we've tried to do is to bring people together from diverse backgrounds to begin to have informal discussions, dialogue, etc. And one of the reasons for this, I remember reading an article not too long ago about a number of members of the American judiciary who were all white and were sort of agonizing over the fact that they really didn't know very much about people of color, black people in particular. And so what they did is they formed a judicial studies circle, essentially, and as volunteer, from what I understand, where they began reading Alice Walker, Ralph Ellison, James Baldwin, Toni Morrison, to get a sense of what the life was about in black America. Because they had never, it's like Donald's issue before, never run into people, never really saw them until they were in the court, and then it was usually in an adversarial situation. There's been discussion about the Discrimination Harassment Council. I won't mention that further. but there's also model policies that we've developed for law firms, everything from harassment prevention to how to develop equity policies and how to ensure that workplaces are flexible to deal with a variety of accommodation issues. We've got a number of advisory groups, but principally we have an Aboriginal advisory group called Lodi Odage, which comprises Aboriginal lawyers who give advice to one of our committees, the Equity and Aboriginal Issues Committee, on issues that have an impact on Aboriginal people, and then an equity advisory group, which Andrew is a new member of, and we're very pleased to have Andrew on board. One of the things that we'll be looking to do in the near future is doing a demographic analysis of the profession, which is going to be very interesting. What does the profession look like? We certainly know what the general population is, but one of the ambitions of the Bicentennial Report is to have a profession that fairly reflects the population of Ontario. We have no idea of what the profession looks like in this province. There have been some studies in British Columbia, and I understand there's been some studies in South Wales, but not in Ontario. So it's going to be an interesting endeavor to see what we do look like. What is the impact of more and more women coming into the profession, and what does that mean to promoting equity and diversity in the profession? What does that mean in terms of dialogue with law schools, in terms of creating the sense amongst high school students that one can be a lawyer? An interesting example is a while ago for Black History Month in this room, we had about 80 to 100 people, I would say, who were here for Black History Month, and we did a mock jury selection with Justice Hoylett. And what I thought was interesting, well, predominantly the individuals who came were people of color. There were a number of whites who were in the room as well. And I kind of wondered what they must have thought when they saw every person, whether it was the person who was being the mock crown or the person being the mock defense counsel and the judge, etc., were all black. I kind of would like to have had a moment inside their head. Certainly I know for myself, when I first saw my black teacher, when I saw my first black teacher, it was in grade 8. And I remember this day. I can still see him sitting in that classroom on the edge of his desk. I was so struck with awe that a person of my race was actually the teacher. I've never had a black teacher since. And I wonder what those students must have felt when they saw a black judge walk in robes. He wasn't a mock judge, he was a real judge, black lawyers, and talking then about issues of race. I'll end on that, but just to let you know, there are a number of things that we will be doing and continuing to support events such as these, because they're very good opportunities for members of the profession to come together to develop knowledge and skills and also to share with each other. But also, we'll be looking at various other policy issues, and we certainly will invite you to get involved in some form or another. Just let myself know, or Geneva Yee, who's here from my department, Rachel Osborne, who's over in the other corner. So again, thank you very much.
Thank you, Charles. And as you've heard, the Equity Initiatives Department has done a ton of work in the short time that you've been here. I just am amazed that you guys aren't just tired all the time. But we've seen really, really positive developments since it's been instituted. So I know everybody has to go, probably, but for people who are interested in asking questions, please feel free at this point to raise anything that you'd like to.
Before you leave, we just wanted to make sure that you know that you're invited to a reception on Friday night at the Law Society from 6 to 8 o'clock. The guest speaker will be Jack Greenberg from Columbia University. It will be a wine and cheese. There will be an opportunity to meet numerous wonderful people and to discuss any topics that you would like to further on a one-to-one basis. So we hope that you'll be able to join us, and it's for the Elimination of Racism Day. Thank you.
I guess I better add another announcement, just one more if there are no questions. In addition, the reception on Friday is also part of a conference that's being hosted by the African Canadian Legal Clinic, which is the first Canadian preparatory conference for the World Conference Against Racism that's being held in South Africa next year, 2001. So please come out to the reception, because there will also be a woman, Jacqueline Nozahara, who's from the Office of the UN High Commissioner in New York, who's going to come and talk about preparations for the World Conference. So we invite you to come to that as well.
Before you leave, we just wanted to say thank you. We do appreciate that you're here, that you take these issues seriously, and we believe that it will take a consensus of all of us working together, and this is a great first start. So thanks for coming.